We shall top the morning off with business and immigration law updates. This is a presentation of the Khurana Law Firm of Rockville, Maryland. The chief attorney and counselor at law at this law firm is that well-respected gentleman, Attorney Ramesh Khurana. This morning, our moderator, Attorney Kenneth Haber, questions Attorney Khurana on the criteria for H-1 petitions for professionals. Let's take a look.
Welcome to the Capitol Forum. I'm Kenneth Haber. I'm a former Assistant United States Attorney, and I'm a former Senior Attorney in the Office of Inspector General of Health and Human Services. With me today, we have Ramesh Khurana, literally world-famous immigration attorney. He has clients across this world, across the country, and he's here to enlighten us concerning the world of immigration, which is one that in this area of Washington, D.C. is certainly one of interest. Welcome, Ramesh.
Thank you very much, Ken. I appreciate your kind introduction.
It's my pleasure, and every word was justly earned. Can you possibly tell us if the H-1 visa category is restricted only to some exceptional people?
Not really. Ken, H-1B visa is available for any professional occupation where the entry-level requirement for the education is minimum of a bachelor degree or higher. So, if a person is holding a bachelor degree which is equivalent of US bachelor degree, that's the requirement. The problem really comes when a person is having a 3-year degree from India, because there people can graduate in 3 years, and when they come over here, that's the issue. But this problem can be overcome by combining education and work experience. For every 3-year block of work experience, 1 year education benefit is given. So, when it becomes equivalent of 4 years, then that person would qualify for the H-1B position. Now, another point to be noted here is when we are talking about what kinds of professions are eligible for H-1B visa situation. Now, we have to make sure that this is not the just position requirement that the person should be having a bachelor degree, but that should be the industry standard as well. Like, what will the industry need for that, so that this person is not just trying to manage to bring a person for that particular position, which could be handled by a person who is not even holding a bachelor degree.
I see. Are there a limited number of these H-1B visas?
Oh yes, you know, there is a quota. There is a yearly quota. We say that for bachelor degree, the maximum numbers available are 65,000, and for a master degree there is a special quota, and it is limited to 20,000 numbers. Out of 65,000, which is for the general category, like holding those people who are holding a bachelor degree. Now, 6,008 numbers are reserved for Chile and Singapore people. There is a special treaty between United States and Chile and United States and Singapore. Now, most of the times these numbers are not used. So, these numbers will be transferred to the general category next year if these numbers were unused in the previous year. Another important thing is to be noted is because H-1B numbers are great in demand. So, this is what happened for the current year of 2013. Applications or petitions could be submitted on April 1, and whatever petitions were received between April 1 to April 5th. Now, there was a lottery because petitions received were 120,000 against the quota available of 65,000, and we said 20,000 for master degree. So, the way it works is that a person who has applied under the master cap category, first of all, he will have the benefit of lottery under the 20,000 numbers, and if he does not win any place in the lottery, then he will be considered for the general category. So, this is how it works.
And that 60 and 20,000 is for the whole world? It's not limited just to India, I take it?
That's a very good question. Now, 65,000 numbers and 20,000 numbers, these are available to the whole world. There is no country ceiling as such, and that's the reason I would say about 40 to 45% of H-1B visa numbers, now these are taken away by Indian nationals because of the IT sector.
That's very interesting. You have a bigger pool to be going into the lottery from, so you can get a larger number of people winning the lottery.
That's right.
Do you have a checklist of questions you ask prospective candidates for these H-1B visas?
Yes, Ken, we do have a checklist, because when we are talking about the H-1B visa petition, now this is a function of what the employee has got and what the employer has got. Both of them have to qualify. Employer has to qualify to offer that position to the employee, and the employee has to qualify to take that position. What the employer has got to do? Now, first of all, we have to make sure that it has a federal tax ID. Then we have to make sure how many other employees this employer has, because it all depends upon whether the business is bona fide or a viable business or not. And sometimes we have a problem when these employers are just consulting companies, and this has become a big issue since January of 2010, because the issue is whether there is an employer-employee relationship or not. I give you an example. Let's say that company A. Now, company A wants to file an H-1B petition for an employee, but company A doesn't have any commercial place. The company wants to apply for H-1B employee, and when it is approved, they want to place it at the client site, and maybe between the client and the petitioner or the company, there are two more vendors. The question is whether this company has an employer-employee relationship with the employee who is working at the client site. How do they monitor his working? Whether they are the ones who make promotion decision, whether they are the ones who evaluate their performance. So, all these factors are taken into account, and we have to document these factors very methodically and systematically to prove to the USCIS, so that they are persuaded. So, we tell them this is the way this employer-employee relationship is established. So, that is about the employer. Then looking at the employee, so we want to make sure that person is holding a minimum of bachelor degree or an equivalent of bachelor degree. Like I said, most of the cases, if foreign degree is just 3 years, then we have an issue. So, it should be combined with the work experience. For every 3-year block, there is 1 year education benefit. So, we have to obtain the evaluation report from the evaluating company. So, that way he would, of course, employee would qualify. Then we have to make sure that the position for which we have to file a petition, that would qualify as an H-1B specialty occupation. We talked about those features in our response to the first question.
Does the Immigration Service use the IRS concepts of employee, the W-2 versus the 1099 in this weighing process?
Now, again, that's a good question. Now, of course, immigration doesn't go into it, but when we are talking about 1099 employees or W-2 employees, so when we talk about employees, they are W-2 employees as far immigration is concerned. Like, we are assuming they are giving the right treatment, like they are really 1099 employees, not that they are trying to misclassify those people because they want to save on taxes or social security benefits. We assume that this classification is correct, and those persons who are really employees, they are on W-2s. Sometimes they could be part-time employees as well. So, we will combine part-time employees. If somebody is working 20 hours per week and other person is working 20 hours per week, so this is equivalent to one employee. So, that's the way we do the accounting.
That's interesting.
Yeah.
And does the employer size matter in the H-1B visas?
So, Ken, your question is whether the employer size matters in H-1B situation. I would say usually it does not, but this is a very relevant inquiry, because we talked about the viability of the business. Business has to be a viable one. whether the business can afford to pay an H-1B employee. When we are talking about the wage determination for an H-1B employee, that employee has got to be paid as per prevailing wage determination, which is determined in terms of the labor condition application. And this labor condition application is certified by the US Department of Labor. So, all these factors have to be taken into consideration before any H-1B petition will be approved by the USCIS. And once this petition is approved by the USCIS, then you have to make sure like what types of representations were made in the petition to the USCIS. You have to ensure that all these representations are true and those are adhered to strictly. Like you said, this person will be working at X location. Let us say a person would be working in office location in Washington DC, but in fact the person is required to work in South Carolina. So, he cannot. So, you need to file an amended H-1B petition and you have to also file another labor condition application. And once the labor condition application is certified for that particular location, only then approval will be granted. But I have seen in my practice, sometimes people will move from one employee from the pre-approved location pursuant to the labor condition application to another location which is not approved by the LCA. Then we have investigations by the Department of Labor, and these types of employers are subject to heavy civil penalties, and they will maybe sometime they are debarred from filing other H-1B petitions. So, this is a process which is highly regulated, and I always advise my client to be very careful to comply with what representations you have made in the labor condition application and the H-1B petition.
What sort of documentation is needed for getting your application approved?
Yeah, documentation usually it is filed on form I-129, and which is the basic document, and we have to complete it. And I think in the interest of time, we have to close this segment because the cameraman is already indicating time is up. Maybe we will cover this question in our next segment.
Very good. Thank you very much for this interesting presentation.
Thank you very much, Ken. I appreciate, and I found these questions very interesting, and I am sure that audience would take advantage of these questions and answers, and I will advise my audience that always consult with your immigration attorney so that you make the best possible decision and you protect your interest. Thank you so much for being with us. Thank you, Ken.